Confession to be completed. Tribunal Temporal 4177, Michael Eason versus Marriott International. Counsel, please state your name for the record.
Matthew Hansen for the plaintiff, Michael Eason.
Good afternoon, counsel.
Good afternoon.
Good afternoon, Your Honor. Shalissa Doherty for the defendant, Marriott.
Good afternoon, counsel. Counsel, I know we're here in regards to the renewed motion for summary judgment, and I also understand counsel on either side have agreed to the recording of this motion hearing for the purposes of our pilot program. So on behalf of the court, I thank you for doing that. Counsel, is there anything you want to add to your written papers?
No, Your Honor.
Okay. Counsel, do you want to be heard?
Oh, I'm sorry, Your Honor. I thought you meant additional documents that I would...
No.
Okay. So yes, I would like to be heard.
Sure. Usually counsel doesn't give up the opportunity to be heard, so this is your opportunity, counsel.
Thank you, Your Honor. And I'll reserve 2 minutes to rebut.
Sure.
Thank you. So as you know, we brought the summary judgment motion in response to the defendant's claims against Marriott. In this case, the plaintiff, Mr. Eason, brings the sole claim of negligence against Marriott, in which he's claiming that there was a coffee table misplaced in his guest room, which he tripped over when he walked into the room. It's Marriott's position that in these circumstances, the condition was an open and obvious one, and therefore there was no duty to the plaintiff, which is why they should be granted summary judgment. In this case, the undisputed facts are very straightforward. The plaintiff had never reserved this particular room at this hotel before. He went to his room for the first time, opened the door, or the person accompanying him opened the door. He walked into the room in the dark, and after taking a few steps into the room, he tripped over the coffee table. There were no efforts made by the plaintiff to turn on any lights. As he testified at his deposition, he walked straight into the room, did not look for the light switch. Meaning that the
open and obvious is proceeding in the dark in an unfamiliar area?
Exactly. And just to clarify the facts, I guess, a little bit further, the plaintiff did not state at his deposition that this coffee table was right there in front of the door when he opened the door. This would be several steps into the room. There's a photo which was attached to our motion which shows where he marked at his deposition approximately that the coffee table was located. I have a color copy of that photo. I'm not sure if it came up in color or if it's clear in what was filed, but I do have a color copy if the court wanted to take a look at that.
You can hand it up if you'd like to, counsel.
So the cases that we've cited in our brief that discuss the open and obvious condition in these types of circumstances, they've clearly stated that when one walks in an unfamiliar place in the dark, it's an open and obvious condition, and that a plaintiff should know that it's a dangerous condition that he or she could fall in. There are unpublished mass appeals court decisions, which are virtually identical in that, again, the plaintiff was walking in an unfamiliar place and tripped and fell or was injured in some way. And in both of those cases, the court granted summary judgment, or the appeals court upheld the grant of summary judgment in the defendant's favor. And those cases are the Clark and Ogun case. Additionally, there were two other cases which we've cited in our brief. One is a Mass Supreme Judicial Court case in which the court upheld a jury verdict in favor of the defendant, and again, similar circumstances in which the plaintiff was walking in the dark and had fallen and was injured. And there's also an appeals court case in which there was a jury verdict returned for the plaintiff, which was overturned by the Massachusetts Appeals Court, again, similar circumstances. So, again, the undisputed facts here are very clear that the plaintiff walked into a dark room, in which he could not see. I think he testified that he could see some things, but it was clear that he could not see everything, and it was a darkened room. He walks in and he falls. He did not attempt to turn on any light, and therefore it's clear that it was an open and obvious condition, and Marriott does not owe a duty to the plaintiff in those circumstances. There's a secondary part of our argument in this case. The plaintiff has named Marriott International, Inc. as the defendant in this case. This hotel, it's the Burlington Marriott Hotel. At the time of the incident, it was not owned by Marriott International, Inc., and it was also not operated by Marriott International, Inc. Marriott Hotel Services, Inc. was the managing entity of that hotel at that time. And in order for there to be liability against a property owner or a property operator, there needs to be some sort of control. And Marriott International, Inc. did not have any control over this property. They didn't manage the property. They didn't run the day-to-day operations of the property. They weren't responsible for maintenance or setting up the rooms or anything of that nature. And there's no evidence here that they were, other than a website the fact that they operate the website that allows people to book rooms at any Marriott hotel. In this case, the hotel was run by Marriott Hotel Services, Inc., and they would have been the proper defendant to be named in this case. At the last hearing we had on this motion, there was mention that there would be discovery taken on this issue, and there has been no additional discovery taken on this issue. We've submitted an affidavit from a Marriott representative who has said that this hotel was managed by Marriott Hotel Services, Inc. and was not owned or operated by Marriott International, Inc. Therefore, summary judgment would be appropriate in these circumstances. Thank you, Your Honor.
Thank you. Counsel, I'll hear you in opposition.
Yes, good morning, Your Honor. Good afternoon, Your Honor. I apologize.
Sure.
I'd like to just highlight a few points. In this case, there exists a genuine issue, a material fact for the jury, because what we're dealing with here is not simply somebody walking haphazardly into the darkness. It's a little more detailed than that, a little more complex. What we have here is a culmination of circumstances that have created a defect, all at the hand of the Marriott. We have a coffee table, as counsel had highlighted, that Mr. Eason had fallen over. However, the coffee table was out of place, and I think the picture she showed you, the coffee table was in front of the couch, and I believe Mr. Eason testified that the coffee table was somewhere else when he fell over it, somewhere closer to the door. But also, the other issues here are the lighting in the room. There was virtually no light in the room. There was some light, a small amount of light coming from the curtain area. And when the door was open, when they opened the door to walk into it, there was a small amount of light leaking in from the hallway. But the coffee table itself was still hidden in sort of a very dark room, and hidden by way of a protruding wet bar that also partially obscured some part of the hallway. It's not, or the entranceway, not a large part, but a little bit. And to make matters worse, once you walked in, the door closed, extinguishing any light. So you have sort of this dead zone in the front of the room where there's no light. In the back of the room where the light's coming in from the curtain, there was some light, and he had testified, I believe, he could see some shadows and things like that. I think he testified he could see part of the couch in the lamp, but he could not see what was directly in front of him. And it's that culmination of events, that, or those defects, that have caused this hazard. And I think that's important to note because, again, it's not just a coffee table in front of him. It's not open and obvious. This is not something directly in front of him he can see that he should have been aware of. In fact, this is something he could not see that has been obstructed by all of these things put into place by the Marriott. And it's his contention in the complaint that the preparation of the room by the Marriott was, in fact, the negligent act here. And as far as his actions, meaning walking into a room that is dark, I don't think it's unreasonable for somebody to walk a few steps into a room, especially where when you open the door you see the shadow of a lamp ahead of you. think it's very reasonable for somebody to walk forward and maybe want to turn on that lamp. Counsel has highlighted that he did not, or he testified that he did not turn on the light switch or did not seek to turn on the light switch. I think that that piece of deposition testimony is related to when he was directly asked if he turned on or sought to turn on the light switch as shown in the picture on the right-hand side of the room that was handed to you. He didn't seek to turn on that light switch because he didn't know it existed. He didn't know it was there. He wasn't looking for it. I'm sure, of course, he was looking for a light. It was a dark room, and had he known it was there, he probably would have turned it on, but he didn't. So with that particular issue, I think he was asked regarding that particular light switch. But again, I think it's reasonable for somebody to take a few steps into a room, yes, unfamiliar to them, but the idea of walking into the entranceway of a hotel room is not unfamiliar. One would expect the entranceway of a room, especially a hotel room, to be free from effects in front of them that they might fall over. The cases cited by counsel...
But even if they're proceeding in the dark, counsel, meaning...
Yes.
Okay. Meaning that you don't think that qualifies as open and obvious?
Proceeding in the dark, is that in and of itself open and obvious?
Into a hotel room, let's put it.
Okay.
Yeah.
Sure. Well, I would say no, and if I can just elaborate on that,
Sure.
and I'll draw a connection to the cases counsel cite in their motion. I believe it's the Ogney and Clark cases. One's dealing with, or at least one of them dealing with a dark, a backyard that was dark. An individual walking around without a flashlight and tripped and fell. One would expect there to be lots of items in a backyard, whether it be toys, bricks, rocks, anything. It's a backyard. And when you're roaming around a backyard, spending an extended amount of time walking around a backyard, you're sort of putting yourself at risk. However, this is not a large area somebody's roaming around. This is not a large area somebody's walking back and forth a few times, subjecting themselves to a large amount of risk. This is somebody who took just a few steps into a room where there's a lamp right in front of them. I understand that somebody walking into pitch black darkness might be construed as holding some liability, but again, this was not pitch dark when he walked in. There was some light coming in. So even the idea of darkness, it's not 100% here. There was some light. He could kind of see some things, and it wasn't until the door closed behind him that it became pitch black and he had already sort of taken a few steps. So on that particular question, Your Honor, is it open and obvious to walk into a dark room? I think my answer is it was not completely dark, and there are also all these other issues in play where I think taking a few steps towards a lamp in front of you is not unreasonable.
Thank you.
And I think that, let's see.
Do you want to say anything on the ownership?
Yeah, okay, I'll go into that. I'll just reiterate sort of what's in my opposition. And what counsel also noted was, in my opposition, I cited to some web pages. The web pages are Marriott.com, I believe, or basically the web page that you can go on that is identified as Marriott International by the bottom of the web page that I believe says copyright 1996-2012 Marriott International Inc., all rights reserved. The web page identifies itself through that insignia as a Marriott International website. When you go onto the website, you can bring up their Marriott Burlington Hotel, the one subject to this incident, and you can identify a date in which you want to rent a room. You can pay, you can book, you can do all the things one who controls a hotel would ask you to do. I think that by holding yourself out as a Marriott company that can rent to you a Marriott room at this particular location, then you are in fact in control of it. If it was Joe's booking service for the Holiday Inn, I could see where there might be a difference there, and somebody might say, wait a second, are they maybe just some sort of contractor? But here, it's the Marriott International availing to the world that they will rent to you a room at the Burlington Marriott. And I think that right there shows that they're holding themselves out as that particular entity, or at the very least, having control over that particular, not entity, that particular hotel. Thank you, Your Honor.
Counsel. Counsel, any rebuttal?
Yes, Your Honor. Just to address the issue of looking for the light, it wasn't the plaintiff's testimony that he was looking for a lamp, or the lamp to turn on a light in the room. And I'm paraphrasing here, I don't have the direct testimony in front of me, but when he was asked about whether he looked for a light switch, his response was that he had 2 bags in his hand, so no, he did not. And so just in general, his testimony was, no, I was not looking for a light switch. I was walking into the room, I had 2 bags in my hand, I was just trying to get into the room. It was that type of situation. So it wasn't, the testimony was not that he was looking for a lamp to turn on in the room. The testimony was that he walked into a room in the dark, that he knowingly walked into a room that was dark, where there was very little that he could see. And that is why, in this case, it's an open and obvious condition, because he had the knowledge that the room was fairly dark and that there was very little in the room that he could see. And he had the ability to turn on a light or to have his companion turn on a light for him. His companion didn't have to let the door slam behind them to leave them into total darkness. They had the ability to simply turn on a light switch, and it could have avoided, and wait to walk into the room until the light switch had been turned on, which would have avoided him tripping over a coffee table. Thank you, Your Honor.
Thank you. Thank you, counsel, for your arguments today. I'll take the matter under advisement. Thank you.
Thank you, Your Honor.
And counsel, I'll leave this here. I think this might be, is this an original, or can I keep this copy?
It's a copy.
It's a copy.
Yeah.
Thank you. Okay.